and YouTube going. And good afternoon. I'm Karen Engel, and I teach at the law school at UT, and along with Neville Hode in the English department, co-direct the Bernard and Audrey Rappaport Center for Human Rights and Justice. And it's my real pleasure to welcome you to the second lecture in our fall 2021 colloquium, Inequality, Labor, and Human Rights, the Future of Work in the Age of Pandemic. Yiran Zhang will present the lecture entitled Rethinking the Global Governance of Migrant Domestic Workers, the Heterodox Case of Informal Filipina Workers in China. And Professor Willie Forbath here at UT will respond. Now, as some of you may know, we host a colloquium every fall at the Rappaport Center on Human Rights and Inequality. And it's also part of an interdisciplinary seminar that we teach in the law school. This year, I'm teaching it with Rappaport Center's postdoctoral fellow, Nina Ebner, who is, you can see, who joined us this fall after completing her PhD in geography at the University of British Columbia. And the seminar we're teaching is a terrific group of 12 students. And before the speakers come, we meet with them and discuss the paper that's going to be presented. So that's to say, they have all read the paper and had a chance to discuss it in great detail, along with some other reading, and have even sent some reaction papers. So after we hear Yiran's lecture and Willie's response, they'll have the first chance to chime in with questions. Before I introduce our speakers, just a few logistical notes. This is set up, as you can see, as a Zoom meeting, not a webinar, so that we can engage in conversation with each other. And we love seeing your faces and reactions. You can decide whether or not you want to leave your cameras on during the talk. You're definitely welcome to do so. But during the question and answer session, we would like to ask as many of you as you can to turn your cameras on, and especially the students in the seminar to do that. To avoid distraction during the talks, we ask you to hold your questions until our speakers are done. We will use just the simple chat function for people to share questions for the question and answer period, and we should have a good amount of time for that. And we'll say more about that as we start, when we get to that point. And I know some of you might be watching this on YouTube. You won't have a chance to post questions. Well, you won't have a chance to ask questions, but you can post them in the chat and someone will send them to us. So let me now introduce Yiran Zhang, who is a doctoral candidate at Harvard Law School, where she focuses on family law, immigration, and employment law, and also engages in ethnographic research. Her dissertation, which she plans to defend this academic year, examines the intersection of care work and the informal economy through 3 case studies. One is about child care subsidy programs in the US, another about internal migrant workers in China, and the third about is the part you'll hear about today, Filipina domestic workers in China. And the paper that she's presenting to us today is forthcoming in the Georgetown Immigration Law Review. And I understand she still has a chance to make some edits and looks forward to the feedback, but I'll let her say more about that. I do want to add that Yiran is actually the first graduate student we've asked to speak at the colloquium in our many years of its existence. And I sort of didn't really realize that until I thought about it, because I heard her give a talk last fall on some of the work that you'll hear today, and then read an early draft of it. And I just found it very paradigm shifting. And it really stuck with me in a whole bunch of ways. And I kept talking about it and saying, you should read this paper. And then I was like, we should have her come talk to us about it. And our students had a similar experience last week in our discussion about it. Many said it made them think in totally new ways. And I think you all will understand that when you hear her speak in a moment. After she presents, we're delighted to have Willie Forbath as our respondent. Willie is the Lloyd M. Benson Chair in Law and the Associate Dean for Research here at the University of Texas School of Law. He's a constitutional and labor historian and is the author of dozens of articles, book chapters, and essays on legal and constitutional history and theory. He's the author of a classic, Law and the Shaping of the American Labor Movement, from 1991, as well as The Constitution of Opportunity with Joey Fishkin, which is forthcoming, I understand now, at the very beginning of 2022. So we're looking forward to seeing that, having that on our shelves. So after Yiran speaks and Willie responds, Nina and I will moderate the discussion, and we'll say a little bit more about that then. So for now, I would say please join me in welcoming Yiran Zhang, and I'll turn the podium over to you.
Thank you, Karen. And before I put on the slides, I really want to say thank you for having me here. I really appreciate this opportunity to present my work. As Karen introduced, it's still not on paper yet, and I still have the chance to go back to and revise things. So if you have any suggestions or feedback, please let me know. And also, I want to express my I'm especially grateful to the 3 response paper writers. Your thoughtful comments and constructive advice are really helpful for me to rethink my project. And I'm going to respond to your questions during the presentation. And I also look forward to further discussing it after the presentation. And now I'm going to share my screen. So I want to start my presentation with a conversation I had with Emma, a Filipina domestic worker who was working informally in China. I met Emma early in my fieldwork in China in 2019. Another Filipina informant invited me to a birthday party at this outdoor pool. And I described my project to Emma, who's also at this party, and he asked me, he said, "So you're a lawyer. What do you think about us? What do you think is the best law for us?" I gave her the standard lawyer answer, saying that I think the Chinese government should have a migration program so that it can work legally here. And she responded with visible disappointment. She said, "Really? You think legal is better for us? But you see, with a legal visa, you're tied to your employer. You cannot change even if the employer is not good to you. You cannot fight back when they're not good to you. Now I can change employer if I don't like them. So all of my employers here are very good to me." And then Emma's statement to some degree summarized the thesis of my paper. So my paper is based on this ethnographic case study of Filipino domestic workers who are working informally in mainland China. I also compare it to alternative formal migration programs in Singapore. And I'm using this regional story to challenge the conventional wisdom in international labor law, that formality, including formal labor contracts and migration programs, always produce better jobs than informality. Instead, I'm arguing for a comparative bargaining power framework to evaluate how contracts and other background rules, such as immigration law, distribute power and risks among parties in the global care chain. In today's presentation, I will first briefly explain what I mean by formalization consensus in international labor and migration law, and I will explain this project's methodology. Then I will dive into my case study of the informal market in China and its comparison to the formal program in Singapore. The bigger political economy picture here is a new international division of reproductive labor. Due to reasons on both receiving and sending countries, large waves of female labor force are flowing from the low-income countries to take up what are traditionally associated as like women's work inside upper middle class families in both global north countries and emerging cities in Asia. Despite their contributions to both societies, migrant domestic workers are often found in pretty bad working conditions in terms of low wage, long working hours, and sometimes highly exploitative conditions. And the current international consensus, as advanced by both the International Labor Organization and the UN International Organization for Migration uses formal and informal, or regular and irregular, as normative markers for good and bad jobs. And accordingly, they assign different intervention agendas. On one side is a right-centric inclusion approach to bring more workers into the formal labor standards. The milestone international treaty here is ILO's Domestic Worker Convention in 2011. It promotes legal tools such as pre-departure labor contract and special migration programs. On the other side, these international consensus building instruments almost exclusively associate informality with risks and harms, and accordingly assign informal work a more punitive, especially informal work done by migrant workers, a more punitive anti-human trafficking framework. Thus, the international labor agenda promotes these special migration programs as a means to reduce human trafficking. In this process, it prioritizes formalization and sometimes compromisingly accepts the workers' lack of market mobility within these formal programs. At the same time, a more critical approach emerged among labor law scholars that they challenge this dichotomized view of work. For example, Carrie Riddick's paper, like on the screen here, proposes to analyze both formal and informal work under the same governance agenda, under the same governance framework. And Hilal Shamir's work finds that migrant workers under some temporary migration programs may endure higher risks to human trafficking compared to some groups of undocumented workers. And also, Adele Blankett's book on domestic workers, she argues that the Domestic Worker Convention in itself had a more transcending moment, that it wants to advance conditions for both formal and informal domestic workers. And by doing so, it also recognized that domestic workers have a more complicated relationship with legality in the history. However, this transcending moment was quickly sidelined in the following ILO and IMO's overarching formalization agenda. So, advancing this critical approach, my article introduces a paradoxical informal migration corridor between the Philippines and China. China has no formal recruitment programs, but a ban on foreign domestic workers with a very narrow exception. If we look at the countries most Filipina domestic workers are working in, this informal market produces the highest wage and the top-tier working conditions in Asia. The market norm has the longest weekly rest hours outside employees' home, which is a consecutive 24 hours. Many of the workers I've interviewed have independent lodgings. Some workers opt for more flexible working structures like live out, and some workers even find some mobilities outside the domestic service industry in total. From my interviews, 3 Filipino workers intentionally left their formal jobs in Hong Kong and Macau to work in this informal market. Thus, my project is to investigate how law and informality affect bargaining power in this specific scenario. So a quick word on methodology. So my China case is based on semi-structured interviews with 36 workers and 2 agents, and multiple group discussions among the workers and on-site observations of their weekend gatherings in 2019. So how a worker who was highly respected in the community introduced me to this group of Filipino domestic workers in a metropolitan city in China, and I recruited my informants through what is called snowball sampling. So given the specific methodology, I'm not doing a statistically representative study, but this is a pretty common methodology to study migrant domestic workers in all countries, given how hidden this entire workforce is. And all of my interviews happened before the COVID pandemic, which without saying has dramatically changed the entire field of labor migration. I tried my best to follow up with some informants through social media, but the information is more sparse. And on choosing the case to compare, I picked Singapore because of its similarity in many factors, including the employer population, the society's social cultural background, and also its geographic adjacency to the Philippines. Also, previous studies ranked Singapore as a relatively desirable market for Filipino domestic workers. So I'm not making a comparison between an informal market and the worst formal program, but rather I'm comparing it with I would say above average. And now I move on to the stakeholders in my analysis. The 36 Filipino worker informants that I interviewed were all women from the Philippines, except for one Muslim informant, all attend Catholic Church, and their age ranged between 23 and 55. The longest duration they've stayed in China was 13 years. The shortest was a worker who arrived last month. 20 of the informants had worked as migrant domestic workers in other Asian jurisdictions, and most of them do not want to permanently settle down in China, but rather they see it as a lucrative work opportunity. And all of the workers spoke at least some simple English at work, and their language abilities, and also most of them do not speak Chinese. And their language abilities drew two types of employer households. First is the upper middle class Chinese families who wanted English education for their children. And the second type of families are Western expatriates who could not communicate in Chinese well enough to communicate with local natives. And between them stood two types of recruiters. Transnational recruiters connect workers who are still in the Philippines with employers in China, and they facilitate the workers' immigration process. In return, they usually charge a commission fee from the worker in terms of 6 months wage deduction. The local headhunters only connect workers and employers in the same city, and they use the same structure to connect the local domestic workers that they charge domestic workers usually 1/3 of their monthly wage, and they charge the employer a month. So my distributional analysis does not include all actors whose interests are impacted here. And one response paper writer, Irving, in his response paper asks about low-wage Chinese workers and whether their attitude could change the state's immigration policies in the future. So I think two groups of Chinese citizens are mostly directly impacted. First is Chinese domestic workers, and the second group is these upper middle class families. And as informal domestic work happens in private households, local workers in other trades are not even aware of this population's existence, and thus they, as far as I can speculate, doesn't have an attitude for or against it. So for the two groups who are impacted, the upper middle class families see themselves as potential consumers who can benefit from it. And although I don't have interviews to support this, my speculation is that their attitude more or less has led to the state's relatively tolerant treatment of the informal market. And for the Chinese nannies, some antagonism between Chinese and Filipino workers did come through in my interviews, especially when multiple domestic workers work for the same family. The antagonism is partially moderated by the fact that domestic service has a huge labor shortage at this moment. And also, as local domestic workers are pretty marginalized themselves, I don't think their attitude affects the government's policies either. And so now I'm going on to the bargaining power studies. My case study has 4 parts. First, I elaborate a bit the immigration law in action, then the bargaining goals for the workers, and finally their strategies inside and outside their workplace. As I've mentioned, the informal market is governed by prohibition. With a possibility for work visa, workers entered the country on tourism or business visas and simply overstayed them. China's immigration law bans working as, hiring, or introducing foreign domestic workers. Thus, each party in the trade may face some negative legal consequences if the authority knows of their behavior. If reported, the worker most likely will be deported. The agent may be prosecuted for human trafficking. The employer will receive a fine, and the immigration police often put them on a future checking list, which functionally prohibits them from hiring another foreign domestic worker. In practice, due to the chaotic immigration enforcement up to the time of my interviews in 2019, the Filipino community found that illegal overstay per se was not on top of the law enforcement's radar. Sometimes their encountering with the police for other reasons could escalate to an immigration investigation, and the workers had developed various strategies to avoid being deported before or after getting noticed by the police. And despite occasional enforcement, a whole industry still had operated in this loophole for over a decade. Now I turn to the question of bargaining power. As Carol Rethinking argues in her paper, working informally or illegally does not mean that parties are acting outside the law. Rather, the law or the actor's perception, and in some cases what they guess the law is, very much conditions parties' bargaining strategies. So I also analyzed this case along this line of distributional analysis. First, what are they bargaining for? The most obvious answers are higher salaries, longer rest hours, and depending on the workers' family conditions, some of them want more flexible hours. And also the worker groups share this preference for a very relational aspect of the work relationship, or in the worker's own words, whether the employer family treats her like part of the family. The most crucial of bargaining I've learned from attending the group meetings is this. With contract in immigration enforcement a foreign background, and with every player reluctant to evolve in authority, the worker can exit the employment relationship without severe legal consequences if she doesn't like it. Working illegally means that she has already become deportable upon overstaying the visa. Thus, her further behavior in the labor market is no longer directly disciplined by the immigration law. And this makes a huge difference from the worker's perspective. I want to stress here that it does not mean that the worker does not incur any cost of ending an employment relationship. There's always the possibility of losing income if they cannot find another. And there's also the possibility of private enforcement by the employer. And yet the absence of the contract immigration link here distributes the cost of ending a relationship, which includes the cost in a cooperative ending and the risks in the uncooperative one. So in this informal market, these risks are distributed more evenly among the groups. Based on my interviews, I put together a repertoire of local Filipinas communities' bargaining strategy and the strategies they've experienced from their employers and agencies. And so I will focus on the workers' strategies here. The first set of strategies involve participating in the employer's family dynamics, such as forming family-like bonds with one or all of the family members, or taking sides when the family members have arguments. Sociologists also report that migrant domestic workers in many other jurisdictions do similar things in the employer's household. But what makes this case differently, the possibility of change jobs enable workers in this informal market to engage in more antagonistic and more market-oriented strategies. Some simple ones involve looking for a new employer family during the old job, or hopping across multiple employer families. And now I look at two specific examples. In the first example, the worker leveraged the threat to withhold labor for better working conditions from the same employer. This is the example of Alex. She had left and returned to the same employer 3 times in 4 years to get the working conditions she wanted. So she said, after another fight, I left them to work for another family. Madam called me. Madam is her old employer. She was begging me for me to come back. She sent me videos of the 2 boys crying and asking for me. And she said in the phone call, please come back. He cannot live without you, and I cannot live without you. Alex ultimately went back 3 times, and the employer gave her 2 salary raises and agreed to give her weekly off days and some flexible hours to go out during the weekdays. And in her own words, we are finally like families. So it is through exerting this power to exit the specific employment or quasi-family relationship, yet to remain active in the local job market. It is through this specific strategy that the worker was able to make the employer into a more responsible one that treated her with respect and a better wage. And now in the second case, the parties bargained directly with this threat to report the other party to the authority. So when Megan quitted her first employer, both parties resorted to this weapon of threat to report, one to enforce their non-enforceable contract and the other one to break it. The employer threatened her saying, there are many immigration officers around. If you just quit, we might report you. And Megan responded, you think I am afraid? I know all of your information. I know your home address, and your company's name and your company's address. If you report me, I will just report you and your agent. It's not legal for you to hire me in the first place, and you have a big company and you don't want trouble. So in the end, her threat worked and the employer let her leave. So this is a paradoxical bargaining strategy that showed up occasionally in my interviews. Every stakeholder can threat to report because they can always subject the other party to some negative legal consequences. At the same time, the threatening party also doesn't want to realize the threat themselves because it might backfire. And in my interviews, workers were at least using this weapon as often as other parties. And I think this differs from at least what I know about undocumented workers in the United States. I think one significant difference here is that this group of Filipino domestic workers do not want to live in China permanently, so they have less to lose compared to undocumented workers here. And so far, I've talked about the bargaining strategies between the workers and the employers. Outside their workplace household, a lively economic and social network within the Filipino worker community also significantly improved their bargaining positions. Informal workers' immigration status restrained their access to a range of public services such as banking. Meanwhile, it also opened up economic activities that formal migration programs prohibit these workers from conducting, such as renting an independent lodging and trading small goods among themselves. Anthropologists found that migrant workers sometimes function as the human infrastructure for labor migration chains. And I also find similar phenomena in my case that some workers are working as recruiters and informal bankers to facilitate the migration of other workers. Among these activities, independent housing was especially essential to their bargaining power. So even live-in workers, meaning that they live in the employer's household during working hours, even living workers often lease a room in the informal housing market for weekend stays. So it has 2 significant functions here. First is to make it easier to enforce the 24-hour weekly rest hours so they can just stay outside employer's household. And the second, it also makes it easier for them to change jobs or switch to part-time work. And the Filipino community in themselves played a significant role in strengthening workers' bargaining power. The workers shared bargaining strategies, they exchanged job information, and they formed some quasi-standard of what a good employer is at these weekend gatherings. As two response paper writer recognized, the worker community performs some functions of an informal union. Thus, even if most workers bargain individually with their employers or their agents, their bargaining experiences has a very collective lens. By no means do I deny that working informally constrains workers' workplace bargaining power in other senses. One example is their relationship with the authority. Only one informant sought help from the police in the case of wage theft, and 2 or 3 workers had experienced sexual harassment. It did not report it. And other than the material conditions of work, as Irving's response paper points out, workers can also experience mental stress from working illegally. The most challenging part from my interviews is this long time separation from their own families. Very paradoxically, many of these workers work abroad for their children's tuitions, so they often plan to end labor migration when their youngest child completes schooling, which also means that they cannot be there when the children were growing up. So to better understand the benefits and harms of this informal market, I draw a bargaining power comparison to the alternative formal work. For migrant domestic workers, formal migration often happens via temporary labor migration programs specially designed for them. These programs often require the worker to commit themselves to labor for a particular employer and give them formal immigration status if and only if they strictly follow the terms of their labor contract. In exchange for these restrictions, the programs only extend labor standards that are significantly lower than those to the local workers. And often these programs do not provide a pathway to permanent or family settlement. And in my paper, I use Singapore as an example of these formal migration programs. I compare between workers' bargaining power in the Singaporean program and in the informal market that I studied. So due to COVID, I was planning to go to Singapore, but due to COVID, I didn't get a chance to visit. Thus, I mostly rely on secondhand sociological research. And typical of temporary labor migration programs, the Singaporean law attaches the worker's work permit to end sponsorship by an employer or an employment agency. If a worker wants to change to a new employer, the law requires the consent from both the old and the new employers, and it also needs an approval from the Ministry of Manpower. The combination of the work permit sponsorship and changing the rule about change work makes it extremely hard for the workers to initiate a job change without returning to the home country and going through the costly immigration processes. In this asymmetric system, the employer can always invoke the state's power to send a worker back if they are not satisfied with her work. The Singaporean program also has strict regulations over workers, employers, and the employment relationship. The workers are prohibited from working for employers other than the work permit sponsor, residing outside a registered address, starting small businesses, or taking other jobs. It also had pretty intrusive regulations over the workers' personal lives and enforces it through periodical pregnancy tests. On the labor regulation side, although Singapore has not adopted the ILO's Domestic Worker Convention, it has passed a regulation in 2012 to extend more labor protection to domestic workers. So we can see this international consensus is definitely making changes beyond those countries who officially recognized it. So the 2012 regulation prohibits the employers and agencies from various abusive behaviors, including document confiscation, assigning worker dangerous work, and charging a commission fee that's over 2 months' salaries of the worker. It also extends the right to a weekly rest day to domestic workers. The employer has the duty to pay a levy to the state, which, among other things, covers the worker's health care. The state might forfeit the levy if the employer or the worker violates the state regulations. So despite the existence of formal labor standards here, unchanged work permit structure makes the regulatory enforcement unequal among the parties. On one side, the employers are financially liable for the workers' violation, so that many of them zealously act as private enforcers and strictly discipline the workers' behaviors. On the other side, although workers' report of abuses can lead to the employer being prosecuted, the workers' need to stay in a job often push them to tolerate various forms of abuses like under provision of food, passport confiscation, or overcharging commission fees. In other words, the regulations on the employers are under-enforced while those on the workers are over-enforced. And even in such a robust legalistic jurisdiction, parties still deviate from the law. One frequent deviation is part-time work. When the work permit sponsor employer permits, the workers works for another household for some hours in exchange for additional payments. And to some degrees, the parties are also bargaining in the shadow of the law, but the space for bargaining in the formal program is smaller and is more tilted compared to the Chinese case. And in my article, I used the bargaining over the weekly rest day as an example to examine the bargaining power. The 2012 regulation gives the worker the right to 1 unpaid week rest day, but it can be contracted away in exchange for overtime payment. Most workers know about this right, and they prefer to take the day off, and most employers prefer to pay the worker rather than to let the worker out for both work and control reasons. However, in reality, once the employer brings the issue to the table, be it pre-departure, during the employment, or even during renegotiation for a contract renewal, the worker tends to readily agree to give it up at the employer's request because they were afraid that they will lose the job opportunity and immigration status if they said otherwise. In other words, the unequal bargaining structure as created by the work permit in the immigration law chips away the workers' rights that the formal labor regulation creates. And beyond the case study, I am making 2 more general interventions. First, I think this case shows that formality is not an accurate token for better jobs. The labor governance agenda at the international consensus building organizations should go beyond the form of the employment or the migration channel in making normative evaluations and interventions. Rather, international labor scholars and advocates need to focus more on the actual distribution, especially the distribution of bargaining power as a measurement and as a goal of intervention. And more specifically, I argued that the current international labor agenda's compromise on workers' post-arrival market mobility fails to address migrant domestic workers' structural vulnerability. The agenda should prioritize restructuring the power asymmetry in order to empower the migrant domestic workers. So 2 response paper writers, Nicole and Irvin, asked for this case's implications for undocumented workers in the US and its implications for labor advocacy in general. So as I said that during the presentation, that the fact that these Filipino workers don't want permanent citizenship in China have twistedly made it less costly for them to bargain for better conditions at work. And from what I've read, that's not the case for the undocumented domestic workers in the US. And another factor here is the deportation process in China, as it's not organized or based on this right to stay. So it's pretty swift. I've actually interviewed workers who've been deported and came back, and the entire process of deportation took her 15 days. Whereas I've heard immigration cases that can last for months or years here, which I think also makes a difference in how they experience the law. And for takeaways for labor advocacy in general, here actually I was very inspired by Shireen, another response paper writer, Shireen's response. So she proposes that we should formalize the informal as a possible policy response. And more specifically, she suggested first the ILO should codify some benefits of this informal market and thus motivate the sending governments, such as the Philippines, to offer more assistance to informal migrants. And second, we should have more formal, we should advocate for more for formal migration programs that incorporates the benefit workers enjoy in this informal market. And she is very aware of the political reality that most receiving countries don't have the incentives to render migrant workers such benefits. So I share her political pragmatism here, but if I also get to be a little bit aspirational, I especially agree with her second proposition to weave informality's benefits into formal systems. Similar thoughts also emerged from my interviews with the workers. When I asked a group of workers what they wanted the most from the state, and the workers said, we want our life here and a legal visa. We want to do things like how we do it here, but we want to do it legally. So I think this is where I conclude my presentation, and I look forward to the comments and discussions.
Great. Thank you so much, Yiran. I'll turn it over to Willie.
What a wonderful, wonderful paper, Yiran. I'm really enormously impressed and admiring about how this paper brings what is often very abstract in the kind of critical legal literature about how important it is to scrutinize background rules and the distribution of bargaining power, and not attend to the most immediate and obvious legal sort of architecture of relationships like the employers and migrant workers in this case. It's just a wonderful, wonderful paper, which I think will be used by many, many teachers all over the world. And I have to confess that my questions track some of the response papers, and so I'm drawn to simply sort of pushing you a little bit further on them, but also drawn to be very terse because there are many people here, and many of them know a good deal more about the particular world of work that you've been studying and the dilemmas that your paper spotlights. That said, I should also say I think that this presentation is, in one respect, a kind of even better than the paper itself, and here's what I mean. In the paper, to put it somewhat, in a somewhat cartoonish way, a little more exaggerated than I really mean, the only people who are canny and have a clear-sighted idea of the sort of socioeconomic realities, the real world of work relations and sort of avenues of strategy, the ways in which the sort of families employing these migrant workers and the migrant workers themselves can gain an advantage and come out better are the migrant workers and their employers. And rightly, you underscore just how canny and sophisticated the migrant workers are. And you also sort of brilliantly spotlight how they're able to gain an advantage over against abusive families, miserly families, families that ill-treat them or abuse them in one fashion or another. The lawyers, to the extent they appear, are morons. The international legal community are morons. The labor advocates and the labor advocates, to the extent they appear, which is fleetingly, are morons too. They think formality is always better. They expect great things from various kinds of formal programs, and they think that the only proper way to address informality is to wipe it out. And I have no brief for sort of international lawyers being other than morons, or the International Labor Organization being other than sort of myopic. I'm not either an international I'm not an international lawyer, but it ain't my experience that the international or the sort of legal labor advocates in this space, that is those dealing with temporary migrant workers, are quite as dumb as the paper implies. And so it struck me that by now, ages and ages ago, at another gathering that none other than Karen Engel sponsored, about undocumented workers and specifically temporary migrant workers in the US, the consensus or the sort of center of concern, the debate among these international sort of or transnational lawyers advocating on behalf of temporary migrant workers, guest workers as they're called here and in many places, was whether it was possible to construct a decent guest worker program at all. And what they lit on as, I believe, the single most important reform was actually quite close to what I think you light on, which is at the most important single thing to be done is that a guest worker should be able to quit an employer without being deported. That perhaps a program with no path to citizenship was kind of something they could live with, but not a program that shackled a guest worker to a single employer, and by implication, at least, not a program that prevented a guest worker from bargaining for a better wage contract or employment situation once he or she was here. So my question is, first, what are some of the other, if you could just name a second important change that the sort of architects of law reform, not the advocates whom I'll come to in a moment, or the activists who I'll come to in a moment, but a right to quit sounds like a pretty right-centric approach. It seems, at least in this space, that even a sort of a kind of strong partisan of understanding the distribution of bargaining power is drawn nonetheless to some of the background rules, in this case, the very prominent one, namely a right to quit, and a right to remain and not be enmeshed in the sort of deportation machinery in virtue of quitting and renegotiating. What else is sort of comes out of this study and your reflections on it? It doesn't seem in this respect to be weaving informality and formality together. With respect, the simpler description is a better formal rule. A better formal rule is a right to quit and a right to sort of light on a better employer. And so that brings me to another question, which is it's an interesting, more paradoxical, even than perhaps than finding on the ground in real time a world of informal, illegal work in the shadow of laws, right? That is actually vastly better in all these measurable ways than the world of a formal temporary migrant worker program. To me, more paradoxical is what one means to weave informality into the work of outfits like Desiree's old employer, the ILO, right? How would a kind of stodgy, sort of old international or transnational labor and work law outfit reckon with informality, right? And incorporate the informal market rather than legalize and regularize it? What would it mean? Clearly, there are spaces, and you found one incredibly riveting one, where informal sort of illegal work is a vastly better deal. It's contingent on a great many things, as you wisely spotlight, but nonetheless, what would it mean to sort of take informality seriously rather than just offer up better formal rules for it? And finally, what about activists and advocacy? There don't seem to be activists and advocates in the world you capture. Rather, as is the case in many parts of the world and has been for all time, workers are their own advocates. Their communities are their own advocates. Right? They help one another. And insofar as they're activists, I don't see them in this story. And I wonder what sort of forms of advocacy and activism, either in this Chinese city or elsewhere in the world, sort of, do you see, enriched by your story? And there I'll stop.
Do you want to take a few minutes to respond to that, Yiran,
Sure.
before we open it up?
Sure. Thank you, Professor, for that. I really appreciate your very thoughtful and very very rich comments to my paper and to my presentation. So at first I want to say I'm not saying that international lawyers and international activists are morons. That's not what I'm saying. And also I will start answering your questions about activists. So I didn't study too deeply into how the Domestic Worker Convention was made, but I did read in the deliberation process of the convention, the civil society advocates, usually it's not labor, at the time it was NGO type of advocates, and then they became a international federation union type of advocates from Asia, especially from Hong Kong and Singapore. It did bring to the table that these work permit laws are really the most horrible parts of these programs. So I think they are aware that the burdens from the work permit laws that they're, but I think, but it was for some reason that it was not more broadly reflected in the convention itself, although I think it contributed to this, why Professor Blanket called it a transcending moment, that there is some recognition of informality is good in the deliberation of the convention. So that's the activist part. And what other proposal I have other than this right to quit. I think a more formal way is to give the worker a right to quit. A more informal way is to enforce the immigration law part slightly loosely or slightly or just like if there's a way to factually remove the employer's capability to invoke the immigration law machine, then it will also like make the asymmetrical system a little bit symmetrical, like less asymmetrical here. So I think that would be an informal way to do a formal right. And another background rule here is really this community among the workers themselves, where they function both as advocates and they also function quite as like businesswomen. That's because they conduct a lot of economic activities with each other. So they actually profit from making more Filipino friends. So they have both altruistic and some economic reasons to befriend new workers, to introduce them to the group, to teach them how to navigate this informal market, which turns out to be very effective in making a difference in the workers' lives. So I think if there is a way to upskill like the communities, either it be more formal, like be a formal union or some informal ways to support the informal community, I think it would be extremely helpful for the workers. So yeah, that's my response. But really, I appreciate your comment.